Good day, sir. My name is Fritz Kenneth S. Cornelio, and today I'm going to answer my final examination for CLJ 400. Number 1. Define evidence and explain its scope. Evidence is a means of ascertaining truth. Truth in the judicial sense is the version of facts that parties were able to prove through the evidence they presented in court. Otherwise stated, evidence is the way of knowing the who, what, where, how, and why of a case. Scope of evidence. Revised rules of evidence. Rule 128, Section 1. Evidence divide. Evidence is the means of sanction by these rules of ascertaining in the judicial proceeding the truth of respecting a matter of fact. Revised rules of evidence. Rule 128, Section 2, Scope. The rules of evidence shall be the same in all courts and all trials and hearings, except as otherwise provided by law or these rules. Number 2. What are the three kinds of evidence? Briefly explain each. Kinds of evidence. Revised rules of evidence. Rule 130, Section 1. Object as evidence. Object as evidence are those addressed to the sense of a court. When an object is relevant to the fact in each, it may be exhibited or examined or viewed by the court. Revised Rules of Evidence. Rule 130, Section 2. Documentary evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or equivalent or other modes of written expression offered as proof of a content. Photographs includes pictures, drawings, stored image, X-ray films, motion pictures, or videos. Revised rules on evidence. Rule 130, Section 22. Testimony confined to personal knowledge. A witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are driven from his own her perception. Number 3. Distinguish corroborative evidence from cumulative evidence. Corroborative evidence is additional evidence of a different kind of character, tending to prove the same point. It is a piece of evidence that may be driven from various sources but proves a common point. Meanwhile, cumulative evidence is additional evidence of the same kind of character, tending to prove the same point. This is purely the accumulation of similar evidence that is driven from common source. Number 4. What is prima facie evidence? Prima facie evidence is evidence which, if unexplained or uncontradicted, is sufficient to sustain a judgment in favor of the issue it supports. Otherwise said, if the opposing party does not offer an explanation and present contrary evidence, then the prima facie evidence will be enough basis for the court to rule in favor of the party that offer the prima facie evidence. Number 5. What about statement uttered as part of the res geste? The requisites for res geste of spontaneous statement are the following. 1. There is a startling occurrence. The main fact is the event that shocked the sense of the persons who perceived it. 2. The res geste act of declaration is about the startling occurrence. The declarant must have made the statement because of or referring of the startling occurrence. 3. The res geste act as declaration is spontaneous. The performance of the act or the utterance of the exclamation was not planned. They are quick and immediate reaction to the shocking occurrence. To determine whether the statement are spontaneous, the following factors may be considered: that the time difference between the occurrence of the main event and the expiration of the statement, the place where the statement is made, the condition of disposition of the declarant where the statement is made, the presence of absence of the other events during the interval between the main event and the making of the statement, and the nature and the circumstances of the statement itself. Number 6. What is the order of examination or of individual witness? Briefly define each. The examination of witness conducted by the party presenting the evidence in chief is called direct examination. In criminal cases, it is the prosecution that is typically given the first opportunity to present a witness, unless the court orders a reverse trial, where the defense presents evidence first. This means that the prosecution goes first is asking its witness questioning to establish the allegation and the information. When the prosecution propounds question to its witness, the prosecution is conducting the direct examination its witness. As a matter of due process, the opposing party is given the opportunity to question the presenting party's witness. The questioning by the opposing party is called cross-examination. In criminal cases, after the prosecution has accomplished the direct examination, the defense will be given the opportunity to do the cross-examination. During the cross-examination, the defense can ask the witness question to check if the witness is qualified to be a witness, has a personal knowledge of the allegations he or she has testified about, and saying the truth. Number 7. Briefly explain what is judicial affidavit. A judicial affidavit is a statement of a witness given under oath, intended to take the place to their testimony in court, given during the direct examination. Otherwise said, it is the question and answer exchange of the counsel and witness in written form offered as evidence for the party's case. In their judicial affidavits, witness answer questions relating to how they come to know of the facts that they are testifying upon, the facts that are material to the issues of the case, in the identification and authentication of documentary and object evidence. Number 8. An offer of compromise in criminal cases is an implied admission of guilt. What are the two exemptions? In criminal cases, the submission of judicial affidavit is mandatory where 1. The maximum of imposable penalty does not exceed 6 years, and 2. Irrespective of the penalty, an accused agrees to use judicial affidavits in lieu of direct testimonies. The GAR, irrespective of the penalty, also applies to the civil aspects of the criminal case. Number 9. In order for evidence to be admissible, it must be relevant and competent. When evidence is relevant, when evidence is competent. Relevance. Under Republic 128 Section 4, evidence is relevant if it has a relation of the fact in issue to an induced belief in its existence or non-existence. From this rule, we gather there are two: competence and relevance. First, relevant evidence has a relation to the fact in issue. If there is a relationship between the evidence and the fact in issue, then the evidence is material. Second, relevant evidence can lead to us believe in existence or non-existence on the fact in the issue. If the evidence supports our belief that our alleged fact exists, then the evidence has probative value. Competence. In addition to relevance, admissible evidence must also be competent. Under Rule 128 Section 3, evidence is competent if it is not excluded by the law or these rules. If a piece of evidence is disqualified by the law or the rules of the court, and then it is not competent, will be inadmissible. An example of evidence that is excluded by law and it's therefore inadmissible is evidence obtained unlawfully. Under the law, even relevant evidence, it was obtained in violation of the right of the accused, should not be admitted by the courts. This is called the exclusionary rule because the courts exclude the evidence from admission into records of the case and from factual basis of the judgment.